Thanks very much. It's an honor to be here at Columbia and to be back home in New York, which is where I am originally from. This afternoon I want to talk about the intersection of the First Amendment and abortion. I recently gave a talk on similar issues at another law school where I walked in to see flyers advertising it as abortion versus the First Amendment. And in many ways, I hope by the end of my talk and through thinking about it further, you'll see that in many ways it's not really abortion against the First Amendment. In many ways, even if one is pro-choice, I think people should agree that they ought to be able to coexist peacefully. Big picture overview of what I want to talk about. First, I just want to give a quick high-level overview of the major Supreme Court cases that have addressed the issue of speech at abortion clinics. Then I want to talk in a little bit more detail about a case that Jeff mentioned, which is McCullen v. Coakley, which concerns the Massachusetts statute. And I just want to discuss in a little bit of depth the experience in Massachusetts related to regulation of speech at abortion clinics. And that's an ongoing case. And then third, I want to have a little bit of discussion of the broader First Amendment issues that are raised in this context that have importance not only for people concerned about abortion-related speech, but also speech in a wide variety of other contexts. So let's start with the review of the key Supreme Court cases. I'll put them in two big categories for you. The first cases are Madsen and Schenck. These are two cases from the mid-1990s. And these cases concerned injunctions against specific individuals and groups who are alleged to have broken the law, trespassed, blockaded doors, engaged in violence. Those sorts of allegations were at issue in Madsen and Schenck. Those cases led to some fairly strongly worded opinions back and forth at the Supreme Court. The justices had a wide variety of views as to whether they actually believed the allegations or not, whether they believed the findings of the trial courts or not. But at the end of the day, the Supreme Court affirmed different kinds of buffer zone restrictions in Madsen and Schenck, essentially requiring certain individuals and groups who the trial courts had thought had violated the law. And again, there was some dispute about that, but let's just take it as a given for now. Buffer zones that required certain people who had previously broken the law to stay a certain number of feet away from abortion clinics. So in Madsen, for example, there was an injunction requiring the individuals and groups in that case to not come within 36 feet of the doors. And again, according to the trial court, that was justified because in the past, those individuals had trespassed, had blockaded entry, and had harassed patients. So in one category, you have the injunction decisions from the mid-90s. The second key Supreme Court decision on this issue is called Hill v. Colorado, which is a 2000 decision concerning a statute in Colorado that imposed what's called a floating buffer zone. Now, a fixed buffer zone is the kind I just described from Madsen. It's essentially a line on the sidewalk that says you may come no closer than this to the clinic, right? It's fixed in terms of it's a fixed area in which you just simply can't go. Hill created what were called floating buffer zones. And in Hill, the statute in Colorado said that if you are within 100 feet of any medical facility in the state, you cannot approach within 8 feet of another person in order to engage in oral counseling, education, or protest. So it's anytime you're within a certain number of feet of any healthcare facility, you can't come within 8 feet of someone to talk to them unless you get their consent first. So those buffer zones are described as floating because essentially the zone in which you can't enter moves around, right? If no one's in the zone, you can speak at will. So you could just stand in front of an abortion clinic or a dentist office or any other medical office. You could stand there with a sign. That's perfectly constitutional under Hill v. Colorado, right? Under Hill v. Colorado, you could stand still any place you want and hand out leaflets because all Hill outlawed was approaching to within 8 feet of someone. If you stood still and just offer a leaflet, that was fine under Hill. The court in Hill cited three particular aspects of that law that the majority in Hill thought made it constitutional. The first was that the court pointed out, look, this law is not targeting abortion protesters. This law applies at all healthcare facilities because the legislature rightly found that people going into any healthcare facility could be vulnerable. So if someone's going in for heart surgery, they could be vulnerable. If someone's going in for an abortion, they could be vulnerable. If someone's going into a hospital because their wife or husband or child is sick and dying, they could be vulnerable. And the court pointed out that it is because Colorado chose to regulate broadly at all the places where incoming patients shared this same interest in avoiding someone getting right up in their face, the court said it was precisely because Colorado regulated that way that the statute in Colorado was subjected only to intermediate rather than strict scrutiny. So the first thing the court focused on in Hill was broad application to a wide range of facilities. The second thing the court focused on was equal application to all speakers. In Hill, the court said, look, this law is not biased against any one side of any one debate. It applies to used car salesmen, newspaper, people selling newspapers, people handing out leaflets about an election. And the court said it applies to all speakers whether they oppose or support the woman who's made an abortion decision. And the court said that that is the level of neutrality that the Constitution demands. So the second thing the court in Hill was really concerned about was equal application to all speakers. And it said the Constitution demands treating people who oppose the abortion decision the same way you treat people who support the abortion decision. The third thing the court really focused on in Hill, and I say really focused on, sometime pick up Hill v. Colorado if it's not in your constitutional law textbooks, and count the number of times they say the following thing. We're only talking about unwanted speech here. They say it, yeah, at least 6 times, and it's probably more than that. But the court repeatedly says in Hill, look, this law is only about people who don't want to be talked to. And the court says we have a long tradition in places of saying there are certain places that you can, in fact, have some right. The court, pushes back against this characterization, but this is really what they're saying, some right to be let alone. And the court says, this law does nothing to affect the right to speak to a willing listener. So the court says, look, if somebody's walking into the clinic and they want to talk to you, this law doesn't do anything about that. That's perfectly constitutional, and that has to remain constitutional. And if you stay still and you just hand out leaflets, you're not approaching anybody, that's perfectly constitutional. And the court also said that it was particularly important that the law was only an 8-foot restriction, because the court said that preserved the ability of speakers to speak at what the court called a normal conversational distance. And in saying that, the court referred back to the Schenck case, one of the earlier injunction cases I mentioned, which had struck down a 15-foot buffer zone. So the court in Hill said 8 feet preserves a normal conversational distance. In other words, even if somebody doesn't want you to approach them within 8 feet, you're still free to speak to them. You just can't approach within 8 feet, and the 8-foot distance lets you speak at something of a normal conversational tone, as opposed to shouting across the street at them. Those were the key things that the court relied on in Hill to allow this type of floating buffer zone that, again, limited just these close, unconsented to approaches. When the decision in Hill came out, it was widely criticized by people on all sides of the abortion debate. Justice Kennedy, who of course was part of the plurality in Casey, said that Hill overturned 50 years of First Amendment jurisprudence. Professor Lawrence Tribe up at Harvard, who is no pro-lifer, said publicly and in print that the Hill decision was slam dunk simple and slam dunk wrong. It's a widely criticized decision, I think in part because it makes it so easy for the legislature to target speech on unpopular issues. It makes it too easy for the legislature to target its speech restrictions in this type of way. After Hill, in 2000, Massachusetts enacted its first abortion clinic buffer zone law. And I won't get into too much detail about that law, except to tell you that in several ways it was modeled on the one upheld in Hill. So it had some key differences, but on the key point of, is it an outright restriction on all speech, or does it only affect these close, unconsented to approaches? Massachusetts went with the Hill model and said, we're only going to regulate close, unconsented to approaches. In other words, if you want to stand still holding a sign, that's fine. If you want to stand still and hand out leaflets, that's fine. If you get someone's consent to speak to them, that's fine. The only thing you couldn't do under the first Massachusetts law is approach within 6 feet of someone without asking their consent first. In 2007, Massachusetts changed that law.